there's no misunderstanding. Everyone in this building understands how elections work. We depend on them. We understand exactly how absentee ballots can differ. So when the Speaker says that it must be fraud, he can't prove it, it must be fraud, he's just lying to the country. And this is what has really differentiated this decade from the decades that preceded it, people's willingness to simply lie about our elections, to cast doubt on our elections for political purposes.
We begin tonight with the mechanics of American democracy and a direct attack on the voting system. The administration is targeting state and local election officials. They are manipulating election boards. They are planning to deploy federal agents to voting locations. This is a coordinated effort to control the outcome of the upcoming midterm elections. The evidence is documented in congressional hearings. The evidence is documented in sworn testimony. We will examine the facts. The current administration and its allied authorities are aggressively promoting a specific narrative regarding election integrity. An allied Speaker of the House has stated that when absentee ballots show a different result than same-day voting, it must be fraud. That is a lie. The exact claim is that absentee ballot variations are inherent proof of electoral fraud. The Speaker made this exact claim publicly to cast doubt on our elections. Senator Adam Schiff directly addressed this during a recent hearing.
I chaired the hearing of the January 6th committee that was focused on the efforts by the administration in 2020 to pressure state and local elected officials and poll workers. We focused very heavily on Georgia, on the courage of Brad Raffensperger not to find 11,780 votes that did not exist, and the courage of Gabe Sterling, who warned that people would get killed, and sadly people did get killed. Election workers like Ruby Freeman and Shay Moss, who demonstrated great courage when their lives were turned upside down.
Senator Schiff stated clearly that there is absolutely no misunderstanding among officials about how elections work. Elected officials and administrators understand exactly how absentee ballots differ from same-day early voting. They understand how early absentee ballots differ from late absentee voting. The Speaker cannot prove any fraud exists. Because he cannot prove it, he simply lies to the country. This deliberate deception casts doubt on elections purely for political purposes. The administration uses this false foundation to justify extreme measures. They use these lies to control the voting process across multiple states. The forensic evidence comes directly from the testimony of state and local election officials.
And I will say that I think there are two instances. Our state election board in Georgia has taken steps to pass legislation that takes the Secretary of State out of the position of Chief Officer of the state elections and allows them to appoint their own superintendent to do such. So that is one area where they're taking away the power of a decision that they do not agree with and handing it over to someone who they will put in place to make sure that it is the result that they want.
In Georgia, the State Election Board has taken steps to pass legislation. This legislation removes the Secretary of State from the position of Chief Officer of State Elections. The legislation allows the board to appoint their own superintendent. In Fulton County, 2 MAGA election deniers are currently trying to secure a space on the Registration and Elections Board. The Fulton County Commissioners are actively litigating in court to maintain their right to vote yes or no on these nominee presentations. Previously, if a Republican nominee did not secure a 4-vote majority, the party simply presented another nominee. Now they are forcing the issue through the courts to install specific election deniers. In Arizona, the state legislature is considering a bill that would authorize immigration and customs enforcement agents at polling stations. In California, we saw a preview of federal interference during the November election for Proposition 50.
Well, we got a preview in last November's election when we had Prop 50 on the ballot, and the United States Department of Justice, led by, in the Civil Rights Division, led by Harmeet Dillon, sent so-called elections auditors to come to an election in California where there was only one thing on the ballot. It was a statewide election on a statewide proposition. And what we did was we sent observers to each of the polling stations to make sure there was no unlawful conduct, no intimidation, no voter suppression or disenfranchisement efforts by the United States federal government.
The United States Department of Justice Civil Rights Division, led by Harmeet Dillon, sent so-called election auditors to monitor a statewide election with only one proposition on the ballot. This evidence proves a systemic effort to alter election administration. It proves partisan actors are attempting to bypass standard appointment procedures. It proves the federal government is willing to intervene in local state elections. However, none of this evidence proves any underlying voter fraud. The California deployment resulted in absolutely no observed misconduct, intimidation, or voter suppression. We must analyse the power dynamics behind each piece of evidence. Taking the Georgia Secretary of State out of the chief officer role is a direct seizure of power. As Commissioner Mo Ivory testified, they are removing the power of a decision they do not agree with. They will put a person in place to guarantee a specific result. By placing election deniers on the Fulton County Board, they control the certification process at the county level. In the past, removing officials like Brad Raffensperger allowed commissions to produce phony findings to justify the execution of search warrants. In Arizona, authorizing ICE agents at polling stations is a mechanism of intimidation and control. It leverages the power of federal law enforcement to suppress voter turnout in vulnerable demographics. In California, sending Department of Justice auditors to a single-issue state election is a demonstration of federal supremacy. It shows local officials that the federal government is watching and willing to deploy resources to influence state procedures. The goal is to strip power from independent local election officials. The goal is to transfer that power to partisan actors who will deliver the desired political outcome. The greater risk of disruption now comes directly from the national level and the federal government itself.
I still think that the greater risk of disruption and harm to the process comes from the national level, comes from leading federal spokespeople, and comes potentially from the federal government itself, which I think could be the new chapter that was perhaps presaged by the recent activities in Fulton County.
If I could just ask the two remaining witnesses very briefly, what efforts are you making in California? What efforts can be made to try to insulate local elections officials from pressure from their own states? Or in California, where the state can help local elections officials should the federal government seek to intervene in a particular House race, for example.
The strongest defence argument presented by the administration is that these actions are necessary to ensure election integrity. They argue they are preventing unlawful voting. They argue that placing ICE agents at polls and sending Department of Justice auditors is required to secure the ballot box. We dismantle this defence using the law and the facts. A specific federal law strictly prohibits having ICE or military personnel at or near polling stations. The administration is willfully ignoring this statute. 24 Democratic Attorneys General are currently preparing legal actions because this federal law is not serving as an obstacle for the current administration. Furthermore, the defence fails on the facts. The Department of Justice auditors sent to California found absolutely no evidence of unlawful conduct. The administration's actions are based on a documented pattern of targeting opponents, not securing elections. The administration is even using the Department of Justice to launch loose accusations of mortgage fraud against political rivals like Senator Schiff, James Comey, and Letitia James. They are making these accusations despite having absolutely no case. We know from the testimony that Schiff has been completely open with his bankers. The administration knows there is no case. They simply use federal power to harass opponents. Let us review the law in plain English. State and local officials have a legal duty to administer elections according to state law. When a federal administration attempts to place military or immigration enforcement at a polling location, they violate federal statutes. These statutes are designed to prevent voter intimidation. The law protects voters from coercion at the ballot box. Additionally, Congressional oversight is a core legal function of the legislative branch. When cabinet officials appear before a committee, they are legally obligated to answer questions regarding the conduct of their departments. When officials like Attorney General Pam Bondi refuse to answer basic oversight questions, they subvert the law. The committee asked whether the White House border czar took $50,000 from undercover FBI agents. Instead of answering, Bondi relied on pre-planned personal attacks against senators. She attacked Senator Blumenthal. She attacked Senator Whitehouse. She attacked Senator Schiff. The law requires accountability. The administration uses its power to shield itself from legal scrutiny. The legal framework designed to protect the Republic is being battered by those sworn to uphold it. My professional judgment regarding the responsibility and fitness of these officials is clear. The individuals executing these policies lack the basic fitness required for public office. The President operates without a moral compass. He operates under the belief that he can create his own truth through repetition. He chooses his cabinet and his enemies based on television appearances. He attacks those who are effective against him on television. Attorney General Pam Bondi demonstrates a complete lack of independent professional responsibility. She knows she owes her job solely to the President. She acts only to please him. She completely ignores her duties to the justice system. Kash Patel is demonstrably incompetent and willfully disruptive. He leaps onto social media to make false claims. He claimed a murder suspect was in custody when they were not. He humiliates the office he holds. Tulsi Gabbard forced intelligence analysts to rewrite their conclusions. The intelligence community assessed that the Venezuelan gang Tren de Aragua was not controlled by Maduro to infiltrate America. Gabbard forced them to rewrite this conclusion to fit a false political narrative. Analysts who spoke the truth were fired. These individuals are completely unfit to administer the law or protect the democratic process. This analysis relies on an unassailable stack of expert authorities. We have the testimony of United States Senator Adam Schiff. He is the former chairman of the January 6 committee. We have the insights of California Secretary of State Alex Padilla. We have the testimony of California Attorney General Rob Bonta. They are actively litigating to defend state policies. From Georgia, we have the direct sworn testimony of Fulton County Commissioner Mo Ivory. She is currently fighting the infiltration of election boards in court. From Arizona, we have the testimony of Stephen Richer. He is a Republican election official from Maricopa County. He has directly faced the pressure of administering fair elections under national threat. These are sworn public servants. They are attorneys general. They are chief election officers. Their credentials establish the factual reality of the administrative assault on our electoral system. Their testimony provides the foundation for our legal conclusions tonight. We must examine institutional accountability. The institutions designed to protect the law have failed repeatedly. The Department of Justice under Merrick Garland failed. He moved far too slowly against the higher-ups responsible for previous election interference. His extreme caution was intended to restore the department's non-partisan reputation. Ultimately, it functioned as a kind of immunity for the president. This delay gave the Supreme Court the time it needed to drag the process out. It allowed them to make cases disappear completely. Now the institutions are actively weaponized. The current Department of Justice refuses to communicate regarding the baseless mortgage fraud accusations it leaks to the press. Congress is failing to hold the administration accountable. Republican senators admit privately that they are deeply uncomfortable with the administration's actions. They are concerned about the ordering of boat strikes in the Caribbean that may constitute war crimes. Yet, out of fear for their personal safety and political survival, they refuse to act. The institutions are paralyzed by fear and complicity. The procedural consequences are strict and clearly defined. The defence of the electoral system will rely entirely on litigation in the lower courts. 24 state attorneys general have gamed out scenarios involving postal service interference. They have gamed out scenarios for military deployment at polls. They are preparing the specific legal papers and court orders required to counter these actions. Civil society groups and legal organisations will deploy fully to locations targeted by Department of Justice observers. Legal representation is being provided to local election officials who face threats or removal. The procedural reality is a continuous series of legal filings. We will see injunctions, we will see courtroom challenges aimed at mitigating harms day by day. The upcoming midterm elections face direct operational interference. The only remaining mechanism for maintaining the procedure of voting is an overwhelming volume of defensive litigation.